Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And I know it has been forever since I have been on this channel. And trust me, I did not plan on being gone this long, but your girl is back. And before we move on to some different content, I got to wrap up this R. Kelly situation that we left off with covering the trial. So if you guys will hold on tight, I shall be right back. And we are going to pick up with a document that was filed a few days ago by Jennifer Bongine talking about Miss ReShona Landfair trying to get $20 million in restitution. Okay, so as I stated, I really wasn't planning on being gone this long, but there was a lot going on, a lot of things that have happened over the past few months that I just really had to take a pause and regroup and get back on track. And I had hoped to use the time off that I said I was going to take to kind of get my channel up to speed and up to date. But of course, life didn't allow that to happen. But we're going to get there. We're going to hopefully take this channel to the next level this year. And so I thought when I came back, I was just going to finish up on the transcripts that I hadn't read yet. And because I didn't read them. Okay, you guys know from the very beginning, I said that the reason I was recording myself reading the transcripts is because I was going to read them anyway. So I might as well share it, with anybody else who wanted that information. And so I have all those transcripts that I'm probably never going to read. But this new information about, after the trial ends, the attorneys file, motions for the judge to overturn the verdict. They file motions for a retrial and all of that type of stuff. And then depending on how the judge responds, which is usually in the negative, I'm not doing that, then we move on to the appeals process. And I still haven't checked to see what's going on with the New York appeal, but I haven't read anything in the news, yay or nay, on whether or not they are going to hear the case. One thing that did come up was, you guys know the whole Heather Williams situation, where Heather Williams sued Mr. Kelly in a civil suit, and he did not respond, and so she was awarded a default judgment. And the default judgment was $4 million. And at the same time, Midwest Properties, Commercial Real Estate, something like that. It's a company in Chicago, and they actually owned the building where his studio was. They sued him also. He didn't respond. And the reason he's not responding to these civil suits is because he's locked up. And, as we know now in New York, he got a 30-year sentence. So he had more pressing things on his mind than dealing with groupies. And, he knew he owed them people at that studio, right? Because they did evict him from the studio. So he knew that lawsuit was coming. But I'm sure never in his wildest imagination did he think that the judge would enter a default judgment to the tune of $4 million. When the lawsuit was originally filed, it was only for $300,000, which was the bike rent and that type of thing. So I'm sure with that case, he thought that the guy would just be awarded the $300 and some odd $1,000, 300 and something odd $1,000, right? And that would have been the end of it. But instead, the judge awarded $4 million. And so Heather Williams and Midwest have been going back and forth, trying to see who is entitled to get the money first, because basically what they're doing is they're putting a lien on Mr. Kelly's royalties And as the royalties come in, they're supposed to go to whoever is first in line in these lawsuits that he has been defaulted on. But Sony is holding on tight to the money, right? And they've had to go through appeals processes and everything. And so far, the awards have been upheld for the simple fact that Mr. Kelly did not respond to the complaints, right, to the lawsuits. And so they're saying that these are legal judgments. It's up to the judge how much he wants to award people. And unfortunately, because Mr. Kelly did not respond, this is the result of his silence. Well, a couple of weeks ago, Jennifer Bongine took up the cross. Okay. So now she is filing an appeal. And basically what happened is, in the Chicago case, they decided not to prosecute. They've dropped the charges against Mr. Kelly. Heather Williams was a part of that case. So now Jennifer Bongine is basically like, we don't know who this chick is. We don't know her story. We don't know if she's ever met Mr. Kelly. So no, she doesn't deserve this $4 million. So because they really don't know like who Heather Williams is or what was going to be presented in court. And so Jennifer Bongine has her hands full dealing with the appeal in New York. Now she's taking on the Heather Williams case. And now she is about to deal with Miss ReShona Landfair. And that is what we are here to talk about today. So let's get started. So Jennifer Bongine filed this motion. Government's, wait a minute, I think I opened up the wrong file. Let's hold on a second. Okay, guys, I was having a senior moment here. I couldn't find this file. Really, 30 minutes has passed by since I said, hold on a second, for me looking for this file. And then it finally clicked in my brain that it wasn't a regular file, that it was actually downloaded into a zip file that I needed to open. But in any event, this happened this past week. And this is a motion for a new trial pursuant to Federal Rules of Criminal Procedure 33, where the government concealed impeaching evidence that Jane, who we know is ReShona Landfair, hired a legal and expert team for the purpose of seeking $13 million in restitution from defendant and falsely testified about it at trial without correction from the government. Now, I know this says $13 million in the title there, but at some point as we go through this document, I think that number changes to 20 million, but we'll see. So now comes the defendant, Robert S. Kelly, by and through his counsel, Jennifer Bongine, and moves this court to grant a new trial where defendants' due process guarantees were violated, where the government's key witness, ReShona Landfair, denied during her trial testimony that she had made a decision about whether she would seek restitution. In truth, ReShona had already hired a lawyer and a team of experts to prepare a restitution package for this court that the government presents in support of its claim that ReShona is entitled to a whopping $13 million in restitution. Because the government knew that ReShona had hired a lawyer and expert team to create a restitution package for which ReShona paid $55,000 that she seeks to pass along to the defendant. Now, where homegirl got $55,000 from to be paying the lawyer? And what is going to be interesting about this whole thing as we go through it is, if you guys remember when rumors started surfacing that ReShona was working with the feds and that she had been meeting in secrecy and all of this stuff with the feds and going before the grand jury and all that stuff. Remember the attorney Christopher Brown, who came out and said that it wasn't true and that the Landfair family had maintained their story from the beginning. Their story hadn't changed. Okay, why was he the person that actually ReShona supposedly hired and paid this $55,000 to. And why did all of this take place? I believe in like April of 2019. I could be wrong, but I think this started in April 2019, but we'll get to the actual date. So these folks were scamming from day one because the grand jury met in like late April or early May. I want to say it was like around May 6th when the grand jury actually met. So had her and her family already been talking to the attorney about this lawsuit? If it was 2019, then they were already in the process before she went through the grand jury testimony. But if it was a later date, then I'm mistaken about that. But we'll get to the actual date. So there's a note at the bottom that says, according to submissions by Jane's attorney and her expert team, she believes she's entitled to as much as $20 million in restitution. Defendant will address what restitution ReShona is entitled to, if any, in his sentencing submissions. And then it picks back up and says that she failed to disclose this information to the defendant and then failed to correct ReShona's, or the prosecution failed to disclose this information to the defendant and failed to correct ReShona's false testimony on the subject matter during her trial testimony. Defendant's due process rights under Brady, Giglio, and Napue, N-A-P-U-E, were violated, and he is entitled to a new trial. 1. Federal Rule of Criminal Procedure 33 provides that the court, on motion of a defendant, may grant a new trial to the defendant if required in the interest of justice. The Seventh Circuit has interpreted the interest of justice to require a new trial in situations on which the substantial rights of the defendant have been jeopardized by errors or omissions during trial. United States versus Kuzniar. Unlike Rule 29, and that was a case that was heard in the Seventh Circuit of 1989. Unlike Rule 29, Rule 33 confers broad discretion upon a trial court to set aside a jury verdict and order a new trial to avert a perceived miscarriage of justice, but such discretion should be exercised sparingly. And that came from United States versus Sanchez, which was heard in the Second Circuit of 1991. So 2, ReShona testified as the government's star witness at trial on August 19, 2022. During cross-examination, defendant's counsel questioned her about her expectations of restitution in the event the defendant was convicted. Question: and isn't it true that the U.S. Attorney's Office told you that you would be entitled to restitution if Mr. Kelly was convicted, right? Yes. And restitution is money, right? Yes. And you are seeking restitution, or will seek restitution, if he is convicted, correct? I'm still undecided with that. No, that is not correct. You haven't decided whether you're going to seek restitution? No. But you know you have the right to seek restitution. That is correct. And then they have in parentheses R914 to 915. That might be a note at the bottom. We'll have to see what that is. So then number 3, ReShona's testimony was not truthful when she claimed she was undecided about whether she would seek restitution from the defendant. She knew full well she was seeking restitution in an extraordinary amount if defendant was convicted. The government knew it too. 4. Prior to ReShona's and her parents' cooperation with the government, they retained the legal services of Boston-based attorney Christopher L. Brown. Brown negotiated immunity agreements for ReShona and her parents, and further retained an expert team to put together a restitution package on behalf of ReShona for this court. See Brown's attached billing invoice. Okay, so let's skip over to that because we have the invoice here. And so it says, my name is Christopher Brown, and I make this affidavit under the pains and penalty of perjury. I am over the age of 21 and I am the managing member of Brown and Rosen LLC. I am attorney licensed. Child, they got some words missing here. Should be an attorney, licensed in New York and Massachusetts for over 20 years. I am lead counsel in this action and I make this affidavit based on my personal knowledge. I graduated from Boston College Law School in 1998 and I am in good standing with the New York and Massachusetts bar. Now, why do they have a New York or Massachusetts attorney if they live in Chicago? So it says, I have practiced business litigation, civil litigation, intellectual property litigation, and other areas of law in New York and Massachusetts. In 1997, I was a student prosecutor in Middlesex County District Attorney's Office in Massachusetts, and I have an adjunct, and I am, oh my Lord, I have been an adjunct professor at Boston College Law School since 2002. Based on my experience, I am familiar with the legal rates in my areas of practice. In 2019 and 2020, my legal rate was $500 per hour. In 2021 through 2023, my legal rate was $550 per hour. I am counsel to ReShona Landfair in the above captioned action, a victim of the defendant Robert Kelly. So the invoice at Exhibit A indicates the fees and expenses charged to plaintiff for prosecution of the copyright claim in the amount of $54,468. Copyright claim. Okay, hold up. Copyright claim? Okay. The expenses are reasonable and account for 81.3 hours of time allocated in this case for the prosecution of the defendant and representing ReShona Landfair from 2019 through 2023. I personally prepared the bill for the client, Christopher L. Brown. Then it gives his address and his email, and it's dated January 23rd, 2023. Now, I'm not understanding this whole copyright claim, but I guess we'll get to it. So, Exhibit A, it says Brown and Rosen, blah, 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 January 23rd. ReShona Landfair is client 1. Her mother, Valerie Landfair, is client number 2. And her deceased father, may he rest in peace, Greg Landfair, is client number 3. And it's regarding the Kelly criminal matter, M-A-T-E-R, child, legal services. Let's see. Then it has his rates from 2019 to 2020 is $500 an hour, and 2021 to 2023 is $550 an hour. Now I wonder, we were shown that have to really pay him this $54,000 plus dollars if she don't get this $13 or $20 million in restitution she's asking for. So anyway, we're going down these fees. Okay, so April 9th, 2019, I remembered that correctly. It says he met with ReShona in Chicago regarding fight gathering related to Robert Kelly from his client. And that fee was $2,000 because they met for 4 hours. On April 29th, 2019, he had a meeting with his clients in the United States. And let's see, an attorney regarding witness cooperation and interviews, clients 1 through 3. So all 3 of them were there. And that took 5 hours and he charged $2,500. May 1st through May 15th, 2019, negotiation of immunity for his clients. You all know that they got immunity against prosecution for lying during the 2006 trial, or was it 2008? Whenever he went on trial in the city of Chicago, they got immunity against perjury or whatever in that. And then people are saying, the streets to be talking, and the streets are saying that ReShona and her parents had also gotten PPP loans, and that they, I guess, lied about that, or lied about the information they provided on the PPP loan application, and that this is really why they testified was because the government was threatening them with prosecution for the PPP loans if they didn't participate. And I am praying that Jennifer Bonjean digs up that information because, child, she bring up that information, it's a wrap. Okay, so I don't know if Jennifer knows about that or not, but if she brings up that information, honey, they can kiss it goodbye. So in any event, that was 3 hours and $1,500. So on May 24th, 2019, he traveled to Chicago, meeting with his clients and the United States Attorney, which was Angel Cruel at that time. And there was a fact-finding gathering for United States Attorney relating to Mr. Kelly and clients 1 through 3. And that was for 6 hours at a cost of $3,000. May 25th, meeting with United States Attorney Homeland Security and his clients regarding Kelly and ReShona. And ReShona was in that meeting. That was 3.7 hours for $1,850. On June 8th, 2019, a discussion with his clients and the United States Attorney regarding grand jury and fact-finding. That was 0.2 hours, so 20, what would that be? It wasn't that long, okay? 0.2 hours, and that was $100. So that was 10 minutes. I think that was about 10 minutes he talked to them. So June 19, 2019, communications with United States Attorney, grand jury and fact-finding, 0.3 hours. That was $150. June 21st, 2019, communication with clients regarding grand jury. That was a half an hour for $250. October 30th through the 31st of 2019, discussion with client and United States Attorney, waiver of privilege with Attorney Coutron. I guess that's somebody else in his office. That was for 0.4 hours for $200. November 13, 2019, communications with client, waiver of attorney privilege, Mr. Coutron. That was 0.3 hours for $150. November 19th, 2019, communications with client regarding waiver of attorney-client privilege with Mr. Coutron, signed by clients. Video meeting with United States Attorney, clients 1 and 2. That was 0.3 hours, $150. Now keep in mind, he was arrested in July of 2019. So these meetings that are taking place, remember, according to Tasha K, ReShona was writing him. She was sending him money all the time, money on his books while he was at the MCC in Chicago, and all the time knew that she was plotting, clucking and cloaking, lying, plotting, and perpetrating against this man, trying to get her big payday. And I guess if he had responded at some point, maybe none of this would have happened and the attorney would have went away. Or maybe she was trying to get him on the phone to say, hey, if you settle with me and give me X amount of dollars, all this can go away. But of course, he didn't respond to her, so we'll never know. So then it goes on December 3rd, communication with clients and United States Attorney, waiver of attorney-client privilege, Mr. Coutron, relating to clients 2 and 3, which is the parents. That was in half an hour for $250. December 15, 2019, communications with clients and United States Attorney regarding waiver of attorney-client privilege, signed by counsel, for 0.4 hours, and that was $200. December 30th, child, they met, okay, anyway, December 30th, 2019, communications with United States Attorney's Office dash extortion allegations, wait a minute, regarding dash, DASH, extortion allegations and press release approval from prosecutors, and that was a half hour, and they didn't charge for that. Then on February 15, 2020, communications with United States Attorney, review of filed complaint, that was 0.6 hours for $250. March 5th, 2020, communications with United States Attorney regarding trial continued to October 2020, 0.1 hours for $50. And then April 26th through 28th, 2020, discussion with United States Attorney regarding restitution. Okay, so she had talked with the United States Attorney regarding this restitution, so they knew she was seeking restitution, and this is why Jennifer Bongine is saying that the United States attorneys had an obligation to correct ReShona when she made that testimony saying that she wasn't seeking restitution, and this information also should have been in the Brady documents. Let's see, April 26th through 28th, 2020, discussion with United States Attorney regarding restitution. Okay, I just read that. January, and then I'm also wondering, ReShona, we have the dates here when she was talking to them in 2020, right? She was talking to them during the time they issued that second search warrant on those storage units. So was it ReShona that told them about the extra storage unit, or was it really Ariel? That's something to think about. So let's see. Then April 26th, okay, another discussion on restitution looks like $350. January 15th, 2021. So she didn't talk to them for about 8 months. $55, and then January 26, 2021, conference call with prosecutors regarding additional change in prosecutors for trial, 0.1 hour for $55. February 2021, they retained a Dr. Cooper Smith and a Dr. Cooper and a Dr. Smith, and we'll get to that when we go back to the motion that Jennifer Bongine filed, because it gets interesting. So that was 2 hours at $1,100. June 21st, 2021, communications with United States Attorney status conference on July 15th, 2021, and present status of trial motions hearings, 0.3 hours for $165. October 20th, 2021, communications with United States Attorney, regarding additional prosecutors, that was $55. May 4th, 2022, Kelly lawyer's unannounced visit to client's home. Whoa, okay. Wait a minute, did Jennifer Bongine show up at the house? Who showed up at ReShona's house? Y'all heard that? Kelly's lawyer's unannounced visit to client's home. Communications with client and United States Attorney about the matter. 0.6 hours, $330. I wonder what attorney showed up at her house. I wish they had listed here who showed up at the house. Who was still on the case? Was it Jennifer Bongine had taken over this trial, right? Interesting. May 9th, 2022, conference with United States Attorney regarding the Kelly trial, 0.3 hours for $165. May 10th, 2022, communications from United States Attorney to Attorney Bongine and my office, $55. May 24th, communications with United States Attorney to Attorney for June Brown's request to contact my office, $55. May 31st, 2022. Okay, let's go back up here to this May 10th. It says communications from United States Attorney to Attorney Bongine and my office. Okay, so that's interesting because the United States attorneys contacted Jennifer Bongine and his office. So I'm wondering if they actually had a conversation, or was this written communication, or what that was all about. Maybe it was about the visit to the house. I don't know, child. So anyway, May 24th, 2022. Okay, we talked about June Brown. That was $55. May 31st, 2022. Communications with United States Attorney regarding trial issues with client. That was a half hour for $275. June 1st, 2022. Communications with United States Attorney. Trial issues with client. That was $165. June 10th, 2022, communications and meetings scheduled for June 27th, June 28th, and July 8th, 2022. And to schedule those, that was $110. June 24th, 2022, rescheduling conference with United States Attorney regarding meetings with clients. That was $55. June 27th, video conference with prosecutors and ReShona. That was 2.8 hours for $1,540. June 28th, 2022, video conference with prosecutors and Valerie Landfair, which was 1.7 hours for $935. July 1st, 2022, conference set for July 18th, 2022 with prosecutors, $55. Child, I'm in the wrong business because you're going to charge somebody $55 for scheduling a call. I can sit there and schedule some meetings with y'all for $55 that's only going to take 5-10 minutes. So then it says July 11th, 2022, rescheduling conference for July 20th. That was another $55. July 20th, 2022, conference with prosecutors regarding ReShona. That was 2 hours for $1,100. July 25th, 2022, scheduling August 5th, conference with prosecutors, $55. July 26th, 2022, scheduling conference August 9th with prosecutors regarding Valerie Landfair. That was $110. August 11th, 2022, social media posting about ReShona, communications with United States Attorney, and that was $165. August 12th, discussion of potential to file for restitution with client. So during the trial, y'all, he talked to ReShona and they talked about filing for the restitution. And the call lasted 0.4 hours and it was at a charge of $220. And then the following day, logistics regarding trial day testimony for clients, communication with United States attorneys and clients. That was another $220. August 14th to August 18th, 2022, travel to Chicago for Kelly trial, communication with prosecutors and clients, attendance at trial, $16,500 for 30 hours of work. That's not even a full week's of work. This man charged $16,000. So January 1st through the 23rd of 2023, this was last month, drafting and preparation of restitution package with legal research and review of expert reports and research relating to, and then it's blacked out, but we know it's ReShona Landfair for 12 hours, $6,600. I need to up my fee for my content, right? Because I'm obviously not charging enough money for my services. So that balance came to $43,145, and that didn't even include his expenses. So his expenses, April 2019 travel accommodation to Chicago, $373, and that's when he made that statement to the press that they were not participating and that their story had not changed. May 2019, travel accommodations to Chicago, $496. And Jennifer Bonjean needs to bring that up where he got up there and released that statement to the press saying that, you know, the family story was the same as it was in 2008 or whenever he went on trial. So August 2022, flight hotel accommodations to Chicago, $619. Retention of Dr. Cooper, $4,000. Retention of Dr. Smith, $5,835 for a grand total, well, for a total of $11,323, and a grand total of the $54,468 that he claims ReShona paid him. But we know ReShona ain't got no money, because if ReShona had $54,000, $55,000 to pay him, she definitely had money to get her somewhere to live and did not have to depend on Angel Cruel getting her a Section 8 voucher. And Jennifer Bungie needs to bring that up too, that she is defrauding the government with this Section 8 voucher, because people that live on Section 8 ain't got $55,000 just sitting around and paying an attorney to be trying to sue somebody. But anyway, child, let's go ahead and jump back into this. So let's go back to Jennifer's motion. We were at number 5. And so before I read number 5, I am going to read the note at the bottom of the page. This is note number 2. It says, ReShona and her legal and expert team have no standing to argue for restitution or even to present evidence in support of restitution, as they are not parties to this case. And then she's going to get into that because she cites several cases supporting what she's saying. And I'll read what she wrote first, and then I'll go back to the note. So number 5 says, although ReShona falsely claimed at trial that she had not decided whether to seek restitution, the government produced documents yesterday, including billing records from ReShona's counsel, a 9-page motion from ReShona's counsel arguing for restitution in the amount of roughly $20 million, and 2 lengthy expert reports that reflect that ReShona absolutely knew of her intent to seek restitution from defendant on August 19, 2022, when she testified otherwise. Not only did she know of her intent, she apparently invested $10,000 into assembling an expert team to prepare expert reports that supports an outrageous request for restitution of nearly $20 million, as if she was litigating a complex civil case, absent the burden of proof and pesky causation requirements that would be required in a civil litigation. Now, child, let's go back up here and read what this thing says. So, courts have recognized that notwithstanding the rights reflection in the restitution statutes, crime victims are not parties to a criminal proceeding. She's just a witness. And so they have Moreno versus Ortiz, which is heard in 1988. United States versus Aguirre Gonzalez, First Circuit, 2010. Crime victims have no right to directly appeal a defendant's sentence. United States versus Grundhofer, Second Circuit, 1990, holding that a crime victim lacks Article 3 standing to appeal under the MVRA. I wonder why she's using the term appeal. United States versus Storr, 3rd District, 2012, a crime victim has no standing to challenge restitution order. United States versus Mendel, 9th Circuit, 1996, crime victim does not have standing with the VWPA to challenge the district court's order rescinding restitution payments. United States versus Johnson, 11th Circuit, 1993, holding that VWPA does not afford a victim, and then ... so some more verbiage in between these two statements, does not afford a victim standing to appeal the rescission of a restitution order. So I guess she's using these cases to say that ReShona cannot present these documents for restitution to supersede any request that the government put in for restitution, and that the amount that she's asking for restitution restitution is outrageous and would be far beyond what a court would have required him to give her. So let's see, United States versus Monzel District Court Circuit, or DC Circuit, 2011. United States versus Koval, 9th Circuit, 2017. And both of these cases, it was ruled, the holding that it joins the 1st, 3rd, 5th, 8th, and 10th Circuits in holding that a victim of crime may not appeal a restitution order under the MVRA. So I believe that's what they're saying, is that they have these guidelines that the courts go by, and basically what ReShona is trying to do is circumvent that and come up with her own restitution and expect the court to give her this money based on all this stuff, this whatever they done created with Christopher Brown, and that the court should take that up instead of what the guidelines state. So then there was another note that says Mr. Brown also includes an affidavit which is a little puzzling as it references ReShona's copyright claim and seems to have been prepared in connection with a different case. Well, I'm glad she pointed that out, because I was trying to figure out what copyright claim. She thinks she wrote some music or something. What's going on here? Anyway, so number 6, not only did ReShona give false testimony, the government knew her testimony was false and failed to correct it in violation of NAPU versus Illinois, and that's NAPUE if I'm pronouncing it wrong. Or maybe it's NAPU. Okay. And versus Illinois, a second such violation on the part of the government. As Mr. Brown's billing records reflect, he began discussing restitution with the government in April 2020, more than 2 years before ReShona testified at defendant's trial. ReShona, through her counsel, retained 2 experts, Dr. Cooper and Dr. Smith, in February 2021. Prior to April 2022, ReShona subjected herself to a so-called independent evaluation by Dr. Cooper, a forensic pediatrician, retained and paid for by ReShona, who prepared a report on April 30th, 2022, that is entitled Expert Opinion of Dr. Sharon W. Cooper regarding victim ReShona Landfair. United States versus Kelly, 30 April 22. In her report dated April 30th, 2022, Dr. Cooper declares that one of the purposes of the report was to determine restitution. So we got some more notes here. Let's read them. Note number 4, ReShona's request for restitution seeks lifetime care for married of ailments that seem to have no connection whatsoever to harm allegedly committed by the defendant. 5, defendant has only attached Mr. Brown's billing records for the purpose of showing the timing of ReShona's direct involvement in developing a restitution package that belies her sworn testimony and the government's knowledge of ReShona's strong interest in restitution. Defendant does not attach Mr. Brown's letter motion or the 2 expert reports that ReShona paid to have prepared because such information contains confidential medical information about ReShona, but also because such evidence should not be considered by this court, where ReShona is not an independent party to this litigation and has no standing to submit such materials to the court. These issues will be addressed later in forthcoming sentencing memorandum. And then number 6, an independent medical evaluation is not an evaluation conducted by one's own retained expert or doctor. Because basically, ReShona, if you hired these people and you paid these people going to say whatever you want them to say. Isn't that what Judge Ann Donnelly said about the mitigation report that Jennifer Bonjean presented in Mr. Kelly's sentencing Eastern District of New York, that why should she pay attention to that when they paid for the doctors? And so the doctors pretty much said whatever they needed to say to help Mr. Kelly. Well, the same should apply here with ReShona. So number 7, on August 12, 2022, Mr. Brown had more discussions with the government related to filing for restitution. On that same day, an expert report from Dr. Smith of Smith Economics was submitted to Mr. Brown that reflected his lengthy opinion, in which he calculated the value of certain losses subsequent to the injury of ReShona. 8. ReShona, through her counsel, Mr. Brown, paid these experts roughly $10,000 for services rendered prior to her testimony on August 19, 2022. 9. In light of the foregoing, it is simply not believable that ReShona was undecided about whether she would seek restitution from defendant when she testified on August 19, 2022. The documents submitted by the government show that ReShona was significantly motivated by the prospects of restitution to the tune of $20 million, and the government knew this. 10. As defense counsel pointed out, ReShona's motive and bias for a fair area of cross-examination. A motive of $20 million is a particularly... Wait, let me read that again because that didn't make sense to me. A defense counsel pointed out that ReShona's motive and bias was a fair area of cross-examination. Okay, I got it. Okay, sorry about that, y'all, but stuff have to be clear in my head before I go forward. So then it goes on to say a motive of $20 million is particularly strong motive that defendants should have been able to explore with ReShona. The government should have disclosed ReShona's intent to seek extraordinary amounts of restitution, which apparently was the reason she ultimately cooperated with the government. It certainly was obligated to correct her false testimony on this point. Instead, it sat silent when ReShona was less than honest about her interest in restitution, denying defendant his right to cross-examine her interest, bias, and motive. 11. The Supreme Court has held that a conviction obtained through use of false evidence, known to be such by representatives of the state, must fall under the 14th Amendment, Nephew versus Illinois. See also Giglio versus United States, which was heard in 1972. New trial required where government failed to correct false testimony by key witness about a benefit he received for testifying, and the prosecutor should have been aware of the falsehood. The same result obtains when the government, although not soliciting false evidence, allows it to go uncorrected when it appears. Nephew, again, when a conviction is obtained through the knowing use of false testimony, it must be set aside if there is any reasonable likelihood that the false testimony could have affected the judgment of the jury. Okay, number 12. The government will likely argue that ReShona's testimony denying her strong interest in restitution could not have affected the judgment of the jury. Even if this was true for the CP account, can't say that out loud. For the CP counts, ReShona's credibility was critical in various other ways, including whether she participated in acts with her friend Pauline and the defendant when they were underage, rather than when they were the age of legal consent. To credit the story that ReShona, Pauline, and defendant had so-called threesomes in the face of contrary evidence, the jury likely credited ReShona's testimony to this point. Thus, ReShona's credibility was important to the count of the indictment, and her testimony questionable where the defense presented evidence that any threesomes that occurred were after the young women were of legal consenting age. Indeed, in her so-called independent examination with Dr. Cooper, ReShona failed to disclose any of the threesomes that she testified about at trial, which is arguably itself a Brady violation if the government had access to the report. In short, the jury did not accept ReShona's testimony hook, line, and sinker on all matters. Thus, testimony that could have further impacted her credibility, such as her motivation to shape her story in ways that were not entirely honest because she stood to gain significant restitution, as did her friend Pauline, was material and could have affected the judgment of the jury. And I believe it would have impacted them if they knew she was out there. Now, what do y'all think would have happened if they had presented these documents showing that this girl was preparing as far back as April of 2019 to try and get $20 million out of this case? That would have been, they would have declared a mistrial in the middle of this case if this information had been presented during the trial. So 13, although defendant will raise this issue in his sentencing memoranda, restitution is not meant to be a substitute for emotional distress damages or punitive damages. The inherent and primary purpose of restitution is to compensate the victim of crime rather than to affect the criminal in some way. Restitution is not intended to be punitive. United States versus Newman, 7th Circuit, 1998. Awards are designed to compensate victims for losses rather to serve retributive or deterrent purposes. And then 14. If courts are going to permit the government, and y'all, I paused because that didn't really make no sense. That last part didn't make sense to me, because it was added on after the notation of the trial. It says, awards are designed to compensate victims for losses rather to serve retributive or okay, I got it. So restitution is awarded to victims for their losses, and the award could be to serve retributive or deterrent purposes. So basically, when you award somebody restitution, then it should be a deterrent to that person to not do that again, right? Or for other people who hear about the restitution to not engage in that behavior or do what that person did. Okay, that makes more sense. So 14, if courts are going to permit the government and victims to use restitution statutes as a means to end run civil litigation and compensate victims for emotional distress, or to punish the victims, then courts also need to consider whether ex post facto rules should apply and whether defendant has the right under Brady to know if the government intends to seek outrageous sums of money in restitution. It is difficult to deny that the $13 million could be a very strong motivator for victim witnesses and could reflect on the credibility of a witness. So now she's going back to 13 million. So I don't know if it's 13 or 20. Or maybe the extra 7 is punitive damages, which are allowed in criminal cases. Maybe that's what's going on here. So 15, the issues will be fleshed out further in defendant's sentencing memorandum, but for the purposes of this motion, defendant maintains that ReShona's false testimony regarding restitution and the government's failure to correct it denied defendant of his due process rights, as well as his Sixth Amendment right to confront his accuser about matters that reflected on her credibility. Conclusion: for the foregoing reason, this court should grant defendant a new trial. Respectfully submitted, Jennifer Bonjean. So what do you guys think? People were saying it must be the money. It must be the money. Okay. But you would think that she would have waited until she got the guilty verdict and then went and sued him in civil court and prayed that he didn't respond, and then she would have got a default judgment, which is what Heather Williams did. So Heather Williams really was the smart one, because she was like, child, whether these people take this man to court or not, I am about to get mine. So I'm going to get my money ahead of everybody else. Heather Williams was like, I don't know what I'm gonna say if I ever get called up on that witness stand, and I don't know if they're gonna be able to prove that I was lying on the witness stand. But I'm about to get this money early because she filed that lawsuit. I think she filed that lawsuit like a week after what's her name? Child, Kim Fox. Heather Williams filed her lawsuit right after Kim Fox said she was filing these charges against Mr. Kelly. And she was pushing for a default judgment at the gate. I think the first default was like in March or April because he didn't show up or didn't respond. And then they sent lawyers in to get it reopened. So they reopened it. And then those lawyers quit. And she got another default judgment. Then they had first he had no lawyer. That was the first default. Then he had the Middle Eastern guys. I can't think of their names, but if you go back and look at some of the pictures of him going to court in Chicago, there's 2 Middle Eastern guys that are walking with his entourage. They're attorneys. So then they took on the case. And then in February of 2020, they quit. So then he had 30 days or 20 days to get a new attorney. Didn't get an attorney. Then it was a default judgment. Then Brian, what's Brian's last name, y'all? I can't think of Brian's last name. But anyway, Brian came in and got that default overturned, right? And then he dropped out of the case, and we got another default judgment. Then there was some guy, Zepito or something, like Zipolo or something. He came in, and the judge was like, okay, enough is enough. And then Sony got involved, because Sony was like, we ain't giving nobody nothing. We putting a freeze on this money. Nobody get these judgments. And it kind of was a good thing, because especially if they can get these judgments overturned, because that's why the Eastern District of New York can't get any money for the people that testified in that case, is because it's $8 million in holes on his money, and it's going to take him forever to make $8 million. So they was like, child, Ariel, here go them $300,000 that Richard Arline promised you, when he was trying to bribe you into not testifying. So girl, take these $300,000 and go on. And then I think somebody else got a few $1,000s, and then we ain't heard nothing else about the rest of these people. Or at least I haven't been in the portal to pull any documents about any more restitution that was going to be paid. But anyway, guys, maybe ReShona should have filed her lawsuit back in April too, and she would have got a whole bunch of money, I believe. But now she's kind of tainted the process. So we'll have to wait and see what happens. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.